As an employer, keeping up with changes in labor laws and regulations is crucial to manage legal risk and ensure compliance. The Fair Work Legislation Amendment Act of 2022 is the latest raft of changes that can significantly impact how you manage your workforce. Hi, I'm Chris Fiesel, a solicitor at WilliamsonBarwick, an employment and industrial law firm. Join me as I break down the key provisions of this landmark legislation and offer practical insights and tips for employers to implement the necessary changes to stay compliant and promote a fair and equitable workplace. The first notable change I'll discuss is the prohibition of pay secrecy. Discussing pay and working conditions has traditionally been considered inappropriate in the workplace and has at times resulted in disciplinary action. However, since the 7th of December 2022, employers are no longer allowed to prevent employees from disclosing their salary and terms of employment that may affect their pay. Similarly, employees can now ask their colleagues about their pay and employment conditions. This right is now protected by law, and any adverse action the employer takes against an employee because they are exercising this right can lead to legal action. Another thing to note is that employment agreements that have a pay secrecy clause that requires an employee to keep their pay rates confidential will become invalid once they are amended, and the new employment agreements can't include these clauses at all. Employers who violate this prohibition after the 7th of June 2023 may be penalized up to $63,000 by a court. The second change relates to fixed-term contracts and how they can be used for and when. Fixed-term contracts are agreements that last for a specific duration. Starting from the 6th of December 2023, employers will be limited to using fixed-term contracts for a maximum of 2 years. This means that after this date, employers will not be able to use fixed-term contracts for a specific role beyond the specified 2-year period, including renewals, and for more than 2 consecutive contracts, whichever is shorter. There are, however, a few exceptions that may apply depending on the nature of the employee's role and whether it's government funded. The 2-year limitation won't apply if the employee is hired for a specific task that requires specialized skills, and if the employee is hired during emergencies or temporary absences of other employees, if the employee's earnings exceed the high income threshold for the year, which is currently $162,000 per year, if the government funds the position in full or in part for more than 2 years without prospects of renewal. Other than in these exceptional situations, if a fixed-term contract exceeds 2 years, the employee will be considered a permanent employee, and the end date that's otherwise been agreed under the relevant contract will not have legal effect. If there is any dispute that arises, the Fair Work Commission has the power to conciliate, mediate, or arbitrate with the employee's consent. The third noteworthy change has to do with requests for flexible working arrangements. Under the current law, if an eligible employee requests a flexible working arrangement in writing, their employer has 21 days to accept or reject the request. The employer can only refuse the request if they have reasonable business grounds for doing so. However, from the 6th of June 2023, an employer can only refuse a flexible working request if they have discussed the request with the employee and have made a genuine effort to reach an agreement on changing the employee's working arrangements to accommodate their needs. If an agreement cannot be reached, the employer must consider the impact of their refusal on the employee and have reasonable business grounds for doing so. Reasonable business grounds include it's too expensive, there is no capacity to change the working arrangements of other employees to accommodate the request, it's impractical, it would cause a loss in efficiency or productivity, or it would have a negative impact on customer service. The new provisions encourage employers and employees to collaborate and find a suitable arrangement when the employer cannot fully grant the request. It's also worth noting that the circumstances to make a flexible working arrangement will be extended to be available to a pregnant employee or to an employee who has a member of their immediate family or household experiencing family or domestic violence. The Fair Work Commission will now also have new powers to assist employees who cannot resolve disputes about flexible working arrangements with their employers. This This can be done through conciliation, mediation, or arbitration. Additionally, if the employer fails to provide a written response to the employee's request within 21 days, the Commission can intervene. The fourth change relates to the request to extend unpaid parental leave. Starting from the 6th of June 2023, eligible employees can request an extension of unpaid parental leave for up to 12 additional months, which would make it a total of 24 months. If an employer refuses this request on reasonable business grounds, they must provide a written explanation, suggest a period of extended unpaid parental leave that can be accommodated, or provide notice that they cannot accommodate an extension. The Fair Work Commission will also have the authority to handle unpaid parental leave extensions requests. The fifth and final change relates to enterprise agreement bargaining. The Australian government has significantly changed multi-enterprise agreements. The Better Off Overall test, bargaining disputes, and zombie agreements. These changes include new bargaining streams, a simplified Better Off Overall test, increased powers for the Fair Work Commission to deal with disputes, the termination of zombie agreements unless an extension application is made. All of these changes will also come into effect from the 6th of June 2023. So what must employers do to comply with these changes? Well, there are a few things. Number one, inform senior management and human resources of the changes regarding disclosure rights for employees. Number two, check current employment contracts for any pay secrecy clauses, as such clauses will be voided once agreements are amended or varied. Number three, review template employment contracts before the 7th of June 2023 to ensure that they do not include pay secrecy clauses moving forward. Number four, identify employees on fixed-term contracts and determine whether any exceptions apply. And number five, update your policies and procedures handling requests for flexible working arrangements and extensions for unpaid parental leave. Number six, train relevant decision makers on how to handle requests in compliance with the law. And number seven, develop a strategy to deal with zombie agreement, if you have one, and seek advice if you're interested in making a new enterprise agreement. I hope you found all this information valuable. If you need assistance understanding your new obligations or want to discuss the implications of the changes with one of our lawyers, please don't hesitate to contact us. At Williamson&Barwick, we're here to help you, employers, navigate the impact of the changes and work through the recommended action items to ensure their workplace is compliant.